So we have a quorum.
We do have a quorum.
Great. Good afternoon. I'm calling the hearing of the Assembly Education Committee to order. Please. Will the Secretary please call the roll to establish a quorum?
O'Donnell?
Here. Present.
O'Donnell here. Chavez? Here. Chavez here. Kim? Kim here. My mic is
I cut you off.
right. McCarty? Santiago? Thurmond? Weber? Weber here.
Thank you. A quorum has been established. You know, there's too much noise in the room, though. Thank you. A quorum has been established. We have 23 bills on file today. One bill has been pulled. That bill is AB 912 from Assemblymember Wilk, which is file item number 15. Three bills are on consent. They are file item number 1, AB 58, by Mr. Rodriguez, file item number 14, AB 907, by Assemblymember Burke, file item number 21, AB 1166, by Assemblymember Bloom. We have a lot of bills here today, so we will need to limit testimony to 8 minutes per side in order to get through the agenda. One or more witnesses can speak to each bill, but the combined amount of time cannot exceed 8 minutes. Others in support or opposition can state their name and affiliation and their position on the bill. This limit will be sternly enforced today because we do, again, have a lot of items on the agenda. Bills will be heard in sign-in order, and we're ready for our first author, which is Mr. Gomez, and his bill is AB 1391, file item number 23.
Did we move the consent already, or we're not doing it?
Apparently not.
Did you want a motion for the consent?
We're going to move the consent. We can move the consent now, right? Go ahead, make a motion, sir.
Move the consent agenda.
Second.
It's been moved and seconded. Seeing no comment, members may vote. O'Donnell's aye.
O'Donnell, aye. Chavez?
Aye.
Chavez, aye. Kim?
Aye.
Kim, aye. McCarty? Santiago? Thurmond? Weber? Weber, aye. Scott,
This is. Do we put it on? Do we put it on call?
No, it's out, but they can add on later.
Okay, so it's 4 votes.
It's 4 votes. It's out.
Okay, the consent item is out. Consent calendar. With that, Mr. Gomez.
Thank you, Mr. Chair and members. I'm here to present AB 1391 for your consideration. I agreed to the 2 technical amendments in the analysis which would apply the UCP and the related provisions to P minutes only and to elementary schools which serve grades 1 through 8. I also agreed to amend the bill to return the minutes requirement to 200 minutes in 10 school days. AB 1391 will provide individuals and school districts an avenue to remedy complaints relative to the noncompliance with physical education minutes. Complaints would be subject to the Uniform Complaint Procedure. By doing this, School District across California will be able to save millions of dollars that are currently going to settle litigation. Here to speak on the bill, I have Erica Hoffman representing the California School Boards Association, as well as 2 other witnesses.
Thank you, Mr. Gomez. And let me just make a comment before we proceed. This bill has been double referred to the Judiciary Committee. We will limit debate in this committee to issues relating to education and leave the other issues to the Judiciary Committee to debate, which it would then proceed on to should it pass this committee.
Move the bill.
So to our witnesses and the public, I want you to understand that I will only entertain comments on education issues in this hearing. The amendments we adopt today will be processed in the Judiciary Committee. The bill has been amended largely to take out the PE minutes issue.
Right.
That has been taken out of this bill. It will be amended in the Judiciary Committee. So with that, if your witnesses can proceed. Mr. Gomez.
Erica Hoffman on behalf of the California School Boards Association. As one of the sponsors of AB 1391, we very strongly support this bill as we believe it will provide the clarity necessary to parents and communities, and it will provide a specific process of how to address complaints with regards to the PE minutes and how they're being applied at a school site. The UCP process is one that schools, parents, and communities are familiar with, and it does provide specific timeframes for responses and for actions from the school district. We very strongly support this measure, and we would appreciate your aye vote. Thank you.
Thank you.
Abe Hajela with Capital Advisors Group. I'm just going to limit my comments because we're only dealing with the education issues. There's no change to the current law requirement, and I would just reiterate that the UCP process has a clear process, clear timelines, and that the bill allows someone to go to court if they're not happy with the result after they've been through that timeline. So I'm available to answer questions if there are any, but I'll keep my comments brief here.
Thank you.
Leilani Aguinaldo-Yi on behalf of the Los Angeles Unified School District. For the reasons already stated, we are also in strong support of the bill. Thank you.
Thank you. Ola, do we have any witnesses in opposition?
Support.
Oh, you're in support. Okay, go ahead. Proceed. Sorry.
Thank you.
Okay, so we go to witnesses, then opposition.
Good afternoon. Patty Herrera representing the Oakland Unified School District in support.
Good afternoon. Marta Alvarez on behalf of the San Diego Unified School District in support.
Jeff Aka, representing the California Association of School Business Officials, in support of the bill.
Leangela Reed, representing the San Diego County Office of Education and the Paramount Unified School District, in support.
Leticia Garcia with Riverside County Schools, in support.
If I may, Chair, if our 8 minutes aren't up, I just wanted to say we are working collaboratively with the ACLU and public advocates to try to resolve some issues they have, but that's for the next committee.
Great. Thank you. Thank you. Are there any witnesses in opposition? Please come forward. Your total time is 8 minutes.
Good afternoon, Mr. Chair and members. I'm Liz Gigan with Public Advocates. We're a nonprofit civil rights organization, and we partner very closely with community-based organizations that represent low and middle income students and parents. We appreciate having worked with CSBA Council and assume that some of this will be resolved through our conversations, but our position at the moment is oppose unless it's amended to take out the provisions that require the UCP to be the sole adequate remedy of law. The proposal to allow parents and students to use the existing uniform complaint process or procedure could be very effective in identifying for districts, if they didn't already know, where they need to improve in the delivery of physical education. And it could help students and parents in filing formal complaints without the need to retain counsel. But as we oppose the language to make the UCP the adequate remedy of law and the process that has to be exhausted before exercising their right to go to court to complain. We think that is extreme. The Constitution guarantees every child a fundamental right to a meaningful education and an equal opportunity to attain that right. We oppose any effort to limit access to the courts for the redress of these rights. We have been working with CSBA Council to talk about amendments that will state the legislature's intent to have a rule that's been articulated in prior court cases.
You know what? You're talking about court cases, and that topic is going to be the discussion in the Judiciary Committee. Today, we just want to stick to the educational component.
Great. The educational component, we feel, will be affected by the interpretation of court cases and the inclusion of their reference in the statute. So I guess I will close by saying, please do not let the UCP be the sole remedy for a complaint around this. Thank you.
Thank you.
Mr. Chairman, members of the committee, Kathy Lynch representing the California Association for Health, Physical Education, Recreation, and Dance. We're the statewide organization representing physical education and health teachers, parents, and students. I was a little noisy. It was hard to hear. I think that the minutes were restored to the current law. Is that correct? Is that an amendment? Well, we appreciate very much the author taking that amendment. We have worked with the author's office on this. That's a very important component of maintaining that for physical education. We support what Public Advocates said about the UCP process, and we'll work with stakeholders in judiciary to try to resolve remaining issues. But thank you for taking the minutes and restoring those. Thank you.
I'm Benjamin Driscoll. I'm a freshman at Albany High School, and I'm strongly in opposition to AB 1391. In 2010, a California appellate court case decided Doe v. Albany Unified School District and held that kids in grades 1 through 6 are entitled to at least 200 minutes of physical education each 10 school days. It also held that people like me can go to the courts when their schools fail to provide them with the physical education they need. I'm proud to say that I was Doe in that case, and that I'm here to ask you not to take away all that was accomplished in Doe. By passing AB 1391. When I was in the second and third grade, my class only had physical education twice a week for half an hour. During that time, we weren't allowed to run. Even when we were playing tag, we weren't allowed to run. If you did run, you spent time sitting on the sidelines. I told my parents about this, and I told them about how little time we were getting with physical education. So they did some research, and they found out that I should have been getting 200 minutes of physical education each 10 school days. They encouraged me to attend a school board meeting and speak about my needs and my peers' needs for physical activity during the school day. My parents assured me that the board would listen, and that could make a difference for me and for the other students at the school. So I went to the board. I actually went to the board twice, but both times they didn't really appear to listen, and nothing changed. My parents felt they let me down because the board simply dismissed my concern. Fortunately for me and my peers, though, my parents had the skill set and resources required to pursue justice through the courts. Please don't make a decision that would jeopardize physical education for all children in California's elementary schools, and please don't take away the right to seek justice through our courts when we are denied the physical education we are entitled to and desperately need. I'm happy to be here telling you what happened to me and to my peers, because the same thing is happening to hundreds of thousands of elementary school students across California. Sometimes the people who are responsible for our health, our well-being, and our academic success don't listen. And when this happens, we need access to justice. I oppose AB 1391, and I sincerely hope that you will too. Thank you.
Thank you.